Good afternoon. I'm Hennepin County Attorney Mike Freeman. I'm here to announce that former Minneapolis police officer Derek Chauvin is in custody. Former Minneapolis police officer Derek Chauvin has been charged by the Hennepin County Attorney's Office with murder and with manslaughter.
All right, welcome back to Law and Crime Report. My name is Bob Bianchi. I'll be your host. There was a devastating development to the prosecution by my estimation today. A judge has ruled that the third-degree murder charge against Derek Chauvin can no longer go forward. That charge is dismissed. The government has 5 days stay to appeal that decision. That leaves remaining the second-degree murder charge and the manslaughter charge against Chauvin. The judge also refused to dismiss any of the complaints against any of the other officers. So out of the 9 charges filed, only 1 has been dismissed. But I would like to bring our guests on real quick to talk about the practical, in my opinion, developments of what this means and why it was a bad day for prosecutors. Adam Konta as a senior partner at Konta, Georges and Buza out of New York, a criminal defense attorney and civil litigator and friend of the network. Lisa Lockwood, retired SWAT officer, crime analyst, author, and a law and crime analyst. Welcome to the show, guys.
Thank you.
Okay, here is my reading of this as a homicide prosecutor myself. In the beginning, many legal analysts, despite whatever your feelings are about the George Floyd case, it was horrible by any estimation, believe that the second-degree murder charge that was filed was a little excessive based upon the facts of the case when you consider the law in Minnesota. Specifically, the second-degree murder essentially requires an intentional act to commit the murder, that it was the intent of the individual to do that. That's second degree. Third degree, however, reads as follows, and third-degree murder carries up to 25 years in prison. Whoever with the intent to effect the death causes the death of another by perpetrating an act eminently dangerous to others, evincing a depraved mind without regard to human life, is guilty of murder in the third degree, punishable again by 25 years. He's also charged with manslaughter, guys. And in Minnesota, manslaughter is defined as a person's culpable negligence whereby the person creates an unreasonable risk of consciously takes chances of causing death or great bodily harm of another. Manslaughter only carries 10 years. I want to know your thoughts about this. What the judge did is remove that middle charge, that middle murder charge, which will leave a jury with a draconian decision. Do we believe that Chauvin intended? Now they got to get into the state of mind of Chauvin here. Did he intend to actually cause the death, which is a much higher burden for the prosecutors to prove? The second degree murder, which carries a significant 25-year prison sentence, doesn't require that be his intent, but rather that he acted in a reckless, wanton fashion, as many states would call it. Then you leave the jury with a choice between second-degree murder and the lowest charge, manslaughter, which is only a 10-year sentence. I say defense lawyers are jumping up and down about this. I'm going to go to you first, Adam. I don't understand the judge's reasoning as to why he dismissed that third-degree charge, but I'm sure that was the one prosecutor said, hey, guys, we got that one in the bag here based on these facts. Second degree, much more difficult for us to prove, but we got the third. And that way, the jury won't have to go down to that manslaughter charge. When that third-degree charge has now been dismissed, that leaves prosecutors a gaping hole in which jurors may very well move towards manslaughter rather than second-degree murder. Am I off, Adam?
Well, no, you're not off, but the judge was just bound by the law in this situation. In order to uphold the third-degree murder charge, they would have had to prove that what Officer Chauvin did was not just a danger to George Floyd, but to others around. And I think that they just wouldn't have been able to prove that. So although this is now looking like it's heading towards a manslaughter conviction as opposed to a second-degree murder conviction, we have to be careful how outraged we are in the community, because what the judge did is looked at the defense attorney's motions, was guided by the law, and I think made ultimately the correct decision. If you charge someone, but you can see that it's not going to be able to be proven beyond a reasonable doubt, then it should go. And I think that's what they did here.
Lisa, I don't disagree with that principle at all. But nevertheless, the charge that was dismissed reads, and I'll read it again: whoever with the intent to effect the death of a person or causes the death of a person by perpetrating an act eminently dangerous to others. I don't believe others has to be other than the victim. I think the victim is others. And evincing a depraved mind without regard to human life. It doesn't require intent, it's something less. I see that as problematic, and I have no doubt in my mind prosecutors will appeal this because they know very well a jury may find it hard to prove that intent factor on second degree. And if that is your intent to do that, if that in fact is your intent, how doesn't it also fit the third degree murder charge where the person is acting eminently dangerous to others and evincing a depraved mind, Lisa?
Very true. Trying to prove that is extremely difficult because as a police officer who has arrested people, have gotten people on the ground and used my knee in the shoulder blade and back area when the person still had the ability to breathe in order to control a suspect or a criminal, it's hard to prove that that act within itself was an intent to cause death. So I can use that as a personal reference. The fact that he had difficulty breathing, add that to the equation. The fact that they did call an ambulance, so the intent of killing him on the spot is going to be very hard to prove.
Yeah, so again, when the jury is going to have to be making a decision here, when you're getting into the state of mind of a defendant, and I'm just telling you as a homicide prosecutor, and you have to prove intent, the judge will actually read a jury charge that tells the jurors that intent is very rarely proven by direct evidence. You have to prove it by circumstantial evidence. And you have to prove his intent was to kill as opposed to restrain or do an otherwise reckless act or a depraved act, an act that could have led to the death of another person. So when that third degree is removed, Adam, I think it makes it much harder. We'll see. But do you anticipate, Adam, if you were prosecuting this case, an appeal of that decision for the very practical reasons that I'm bringing out here?
Well, the appeal is going to be based on one word, right? Others. The judge ruled that others means those outside of George Floyd. That was his specific ruling. So they're going to have to find case law that supports that others can be as narrowly defined as the victim himself. If they can do that, then yeah, sure, they'll absolutely appeal it. But if not, then they're really going to have to focus on trying to figure out how, if possible, to prove intent.
Yeah, well, I think George Floyd will be defined as others. That is a good point you are making. Certainly one the defense will make in the case. Nevertheless, if that ruling stands, the prosecution's case has gotten much more difficult in terms of proving a murder charge as opposed to a manslaughter case. Guys, we're going to switch gears a little bit. Are you familiar with this Oxycontin, Purdue Pharma, maker of Oxycontin, has agreed to plead guilty to 3 federal charges that basically deal with the anti-kickback statutes for paying doctors, in essence, to overly prescribe, causing a massive opioid epidemic. They are going to be required to pay $8 billion in fines that they don't have. They've already filed for bankruptcy. And essentially what's going to happen right now is the government is going to get into the Oxycontin distribution business, where they are going to basically be taking over, and money that is going to be made from the sale of Oxycontin is going to go to pay those fines and supposedly for programs to fight the opioid epidemic. I will just note that the Department of Justice has also settled a civil case against the company for $225 million. Just some facts that I think are important before I ask for your commentary is the CDC estimates 450,000 people have died of overdoses in the last 10 years. A third of those deaths in 2018 were from prescription drugs. The state's attorney generals have filed 25 of them objections to this. And one of them is quoted out of Connecticut, AG William Tong, saying that this is a mere mirage of justice. The federal government had the power here to put the slackers, those are the owners of Purdue, in jail, and they didn't. Adam, this kind of gets, at least when I was reading it, to these ideas that, and we're going to talk about a story later on about this case, but I want to show you a real quick clip of what this is all about before we get into what I believe disparities in justice and how cases are handled. Let's take a listen.
Subject to court approval, the Department of Justice is announcing a global resolution of our criminal and civil investigations into the opioid manufacturer Purdue Pharma, as well as a civil resolution with members of the Sackler family who comprise shareholders of the company. We have targeted unlawful activity involving opioids at every level of the supply chains. There's very different supply chains on the illicit side and on the prescription side. On the prescription side, this means unlawful actions by manufacturers, distributors, pharmacy dispensers, or physician prescribers, for example. So today's announcement involves one of the most important participants in the supply chain of prescription opioids at the manufacturer level, and a resolution which, if approved by the court, will redress past wrongs and will also provide extraordinary new resources for the treatment and care of those affected by opioids addiction. The global settlement announced today involves the company pleading guilty to 3 felony counts for defrauding the United States and violating the anti-kickback statute from 2009 to 2017. In addition to the company having agreed to plead guilty to these 3 felony counts, the company has agreed to a $3.544 billion criminal fine and a $2 billion criminal forfeiture amount. Further, on top of those, to resolve its civil liability, Purdue Pharma has agreed to $2.8 billion in damages to the United States. Now, the company's in bankruptcy, so the corporate resolution is subject to the bankruptcy court's approval. If it's approved, this will be a corporate settlement in total of more than $8.3 billion. Additionally, members of the Sackler family have agreed to pay $225 million in a civil settlement that will provide civil releases only. It's also important to note that this resolution does not prohibit future criminal or civil penalties against Purdue Pharma's executives or employees.
Okay, Lisa, let me go to you real quick. It doesn't preclude it. We've been in negotiations. We've been in the room. There's winks and nods that go on all the time. If they want to file charges against those people, they should have. Let me just tell you that the DEA has said that Produce Pharma, the company, thwarted the U.S. efforts to ensure compliance and prevent diversion. The devastating rippling effects of Purdue's actions left lives lost and others addicted. We're talking about millions of people that have been affected by the criminality here. And these guys basically are facing no criminal exposure. I think this is when people look at the criminal justice system and they say, sure, 225 million, how much money did they make off the lives of these people? And they're not going to spend a day in jail, at least as of now. What do you think?
I think it's horrific. The havoc that this company and other highly addictive prescription medications have done to not only the loss of life, you talk about 500,000 between 1999 and 2018, an estimate. Let's talk about the people that are in jail. I handled so many cases of people who were addicted to OxyContin, fraudulent prescriptions that were being put out, arrests that were made, the jail population increasing, burglaries because the addiction was so terrible. The havoc wreaked across the country because of just this one singular drug and company is unfathomable. So yes, I would love to see the upper tier and family members be accountable for this.
Yeah, well, it sickens me when I think about the people that we put in jail because they were addicted to opioids and the crime that occurs, sometimes very minor crimes that occur as a result of it. They go to jail. These people so far aren't. We got a lot more on this topic on the other side of the break, so stay with us. We'll be right back. Okay, we're continuing with this Purdue Pharma case. And what was announced in this global, quote unquote, settlement that they have entered into with the company is that since they don't have the $8 billion in the money to be able to pay the fines and they are in bankruptcy, that essentially what's going to happen is that they're going to create a public benefit company controlled by a trust. It will function entirely for the public interest, they say, rather than maximizing profits. Future earnings will go to pay off fines and for overdose rescue drugs to combat the very opioid addiction this company helped to create. Let's listen to Jeffrey Rosen, Deputy Attorney General.
This resolution must be understood against two larger contexts. First, the company's bankruptcy, and second, as I've referenced, the Department of Justice's overarching work addressing the opioids crisis. We'll take the first one first, the bankruptcy. The company's bankruptcy in the Southern District of New York involves many creditors, from some private creditors to federal, state government, and local creditors. In general, the creditors are aiming to ensure that nearly all of the proceeds of the bankruptcy go to opioid abatement programs, and the Department of Justice generally supports that goal. Towards that end, a key piece of today's resolution is based on the future of the company that was Purdue Pharma. The agreed resolution, if approved by the court, will require that the company be dissolved and no longer exist in its present form. It would require that the Sacklers must relinquish all ownership and control of the company or of any of its successors, and the company's assets would be transferred to a new public benefit company, or PBC, owned by a trust for the benefit of the American public. The PBC would be charged with providing its medicines in a manner as safe and possible without diversions, while providing millions of doses of medicines to treat opioids addiction and to reverse overdoses, and otherwise taking into account long-term public health interests. And again, to be clear, the Sackler family will have no role in creating or controlling the new PBC.
Well, Adam, the 25 attorney generals are also complaining they don't believe that the government should be, and let's make this clear to the audience, OxyContin is still going to be sold. They don't believe that the government should be in the drug distribution business, number one. And number two, as a sophisticated criminal defense attorney, I know you know that the DOJ can file civil actions against the company and also pursue criminal actions against the wrongdoers. And in fact, sometimes by doing that, they even get a better settlement. Can you explain to me, one, whether you think this is a good business proposition for the government to be getting into? And secondly, what are your thoughts about the justice of the fact that these people who did these things knowing, allegedly, that people were dying as a result of this and were thwarting an investigation, which typically prosecutors hate, are not right now at least facing criminal charges? What are your overall thoughts?
Oh, well, yeah. First, to your question, yes, it's a great business decision for them because they just co-opted the most addictive, dangerous drug in our country's history. A drug that's led to heroin addictions and, overdoses. We don't need to get back into it. We've all, I've represented so many people whose lives have been destroyed by this. What the government did was they co-opted this business so now they can sell and reap the profits of this highly, highly dangerous drug. I cannot fathom how this was done and how this is possible with the Sackler family, who seemingly knowingly pushed these prescriptions on doctors. They got to withdraw $10 to $12 billion of their personal funds and that was tied up within Purdue Pharma, excuse me. They got to take that money, go back home with it, and now their punishment is, they don't have to be involved in the cleanup, while the government swoops in and makes tons of profit off it, while they're saying that, but we're doing it under the guise of helping the American people. I mean, this is just so different than how the crack epidemic was handled back in the 80s. This is, I would be one of those 25 attorney generals signing that saying this is just a mirage. This is not what should be happening, in my opinion.
Yeah, I think that's a great perspective. And Lisa, I want to go to the point as a crime analyst. The repercussions of what those folks did, we felt all the way down to the local level. When we were prosecuting, I could think of one in particular. It was a police officer that got addicted to oxys because it had a back injury on the job. And the next thing you know, they're out with drug-seeking behavior when the oxys are cut off, dealing with drug dealers, getting heroin, things of that nature. And these folks go into state prison for that. There is just something that is just, when you talk about criminal justice reform, inherently wrong with the distributor, which is typically handled much harsher. Gosh, if you hand a joint from one person to another person is considered distribution. And in my state, you could go to jail for 3-year minimums on that. This is exactly what we're talking about. What do you think?
Yeah, and not just police officers. This is every person in every walk of life who has had some type of surgery or injury and had gotten addicted to it. So all levels, from the impoverished to the wealthy, who have lost family members or members of family members who have been incarcerated for lengthy times. The distribution of this that happened in the underground world of drugs and pharmaceuticals. We see families that were completely decimated because of this. We see our prison population that has increased, and then the people who are actually victimized as burglary victims, robbery victims, murdered because of this one particular drug. Atrocious.
Yeah, well, this shows you the power of the prosecutorial decision-making process and how they can make a huge difference. Guys, let's move into another case. You know, Catherine Magbanwa, she was a defendant in a case for the killing of Professor Dan Markell. This is a Tallahassee judge who has refused to release her on bond. The defense lawyers were making an argument that there was a trial back in October of 2019. Law and Crime Network, of course, covers those trials gavel to gavel. It was a fascinating case, but it was a mistrial nevertheless. A co-defendant was convicted of murder. A third defendant, Luis Rivera, actually was a cooperating witness. Now, Luis Rivera, the cooperating witness, got a 19-year sentence. The co-defendant got a life sentence. She was not convicted. It was a mistrial. So the motion was made before the judge due to COVID and due to the fact that there wasn't sufficient evidence to convict her. She should have been released by the judge on bond. That was denied. Adam, tell me your thoughts about whether or not it was a legitimate motion and whether you agree with the judge's decision here.
Well, it's certainly a legitimate motion. I've had trials that have ended in a mistrial, and one of the very first things I do is then, okay, I'd like to re-argue bail. And it depends on the case. In this particular instance, the charge is so severe. You're talking about a hired murder, and the evidence has not changed, meaning that there still is a star witness who's saying, yeah, she's part of this. She helped plan this. She was the conduit between that arranged this whole thing. A judge not letting her out on bond, even after a mistrial, is not a surprise at all. But the act of doing it is something that every defense attorney would do immediately following a mistrial.
Yeah, and Lisa, this is another thing. Again, I always talk about the disparity of what goes on from case to case. There are many people that do get out on bond. There are ways to protect geospatially map, ankle monitoring, very strict conditions. I mean, the police officers in the George Floyd case, they're out. So why do those rules apply differently to other individuals?
Well, I don't know the reason for the disparity. I mean, we could go into based on race, based on wealth, based on who the attorney is, et cetera. But one thing that we do know is her co-conspirators, alleged co-conspirators, are in jail right now, and their cases have been proven guilty for conspiring, for murdering, and she was, as was referenced earlier, the conduit. She was the middle person. And Luis, who was in jail, childhood friend of her husband, admitted that she was the person who was making it happen and actually supplying the money for it to go forward. So I think with that information, I believe that they should hold on to her.
Adam, well, given the fact that she is in and for a significant period of time, do you envision either prosecutors approaching a defense lawyer, or the defense lawyer approaching the prosecutor saying, look, you got a mistrial on the first case, you got evidentiary problems, you already got 2 people in jail that are accountable for the murder, let's work out a deal and move forward and just get this over with without the need for a trial? Do you see something like that going on behind the scenes?
Well, yeah, because there's also a ton of time and effort that goes into a trial. So you've already gone down this road once. It depends on a couple things. How big was the split of the jurors? If the prosecutors, let's say it was 10-2, if they have any information at all from any of the jurors, then they'll try to figure it out. If they think that they have a reasonable shot at plugging up whatever holes they missed the first go around, then maybe not, because we're talking about murder here. So the sentencing range and the possible plea deals are limiting. But if they can figure out a way to avoid the expense and the effort of a second trial while still coming to some sort of agreement that maybe both sides are a little unhappy with, I guarantee those conversations have happened already. If not, they're going to be happening very soon.
Okay, excellent, guys. Great analysis as always. We're going to take a quick break here. We got more on this case and other cases as we go forward. Stay with us. We'll be right back. Okay, going back to the Mapguana case, Lisa, I want to ask you to kind of pick up on what Adam had just said before the break about this bargaining and that may go back and forth. But a lot of that depends on the strength of the case. This is kind of a little bit of a twisty and a weird case. She was tried with another co-defendant. That co-defendant was actually found guilty and serving a life sentence. It was a mistrial for her. Give us a little basic breakdown of the, well, I'm being told, I'm sorry, that we're going to throw to a clip. And so let's take a look at that first before I ask you my question.
There's only one reason why a single mother of 2 young children would sit in custody for 3 years in confinement, risking it all. She's innocent. That is the only explanation. Let's draw a comparison, guys, please. Let's draw a comparison over to Wendy Adelson, their witness. Somebody who they believe was, I don't know who they think is behind them, that they believe is involved. Their witness, a trained attorney, had to be subpoenaed, had to be given, and the judge explained it, immunity. She laughed at them. Laughed at them. No, I'm not going to be arrested. Ms. Kappelman had her on the stand, somebody she believes is behind this, didn't ask her the tough questions. Had her on the stand and could have put her on the spot and didn't do it. Now, let's compare that witness over to Catherine McBanwell. Not an attorney. No immunity. Didn't have to testify. Everything on the line. Subjecting herself to cross-examination, actual examination by Ms. Kappelman, by a trained and experienced attorney. Grilled on facts from years ago, after years in confinement. Nothing incorrect.
All right, so that was a defense attorney in the closing argument. So, Lisa, that gives us a little bit more context to the question I was asking you. Obviously, he was persuasive enough, that defense lawyer, that the jury did not come back with a conviction, but because there wasn't a not guilty verdict, the case will be retried. Tell us a little bit about the case and what your thoughts are about the second go-around, because we all know as prosecutors, cases typically don't get better for you when you have to try a case a second time.
Unless Catherine decides this time around that she may say something about her involvement with the family. If they give her a good enough deal, is what my belief is. The father of her children, Garcia, who is in jail, childhood best friend of her father of her children, are in jail. They have no relationship to the Adelson family if it were not for Catherine Magbuana. So they don't even know who they are. So what would make these 2 people go out and kill a complete stranger without any incentive whatsoever, crossing state lines to make this happen? Louis said in his own words in his statement that she was the conduit. She was the person who was going to deliver the funds from the Adelsons. So we've already proven that. We know that that's there. My hope going forward with this is that she does decide for her own life and her own future imprisonment that she goes ahead and divulges the information regarding the family potentially setting her up to pay for her to have that deed done.
Yeah, and Adam, you know, as a prolific defense attorney, very, very skilled and capable person, you listened to that defense attorney. He was making valid arguments. At least some of those jurors were listening to those arguments. And what are your thoughts, if you were defending the case, about the idea that it's only going to get better the second time around, because you know that the prosecution's theory of the case, you know how they presented the case, there's transcripts, witness often testify differently. Are all those factors going to come into play in terms of your assessment of the case as a defense lawyer and your assessment to go forward to prosecutors and say, hey, let's just end this. Let's make it reasonable where everybody can hold their nose and we move on in order to avoid the potential of a conviction down the road?
Well, yeah, absolutely. But it's a two-way street, keep in mind. I don't know the intricacies of what happened during that trial, but maybe there was some big emotional witness that really got to a juror. And in that situation, the prosecution will know how to avoid that going forward. So, I've done retrials where it's gone both ways. Sometimes it's been great for me being able to know what the prosecution has coming, being able to have extra material to cross-examine witnesses on of past testimony. But other times it allows prosecutors to plug up the holes and really put on a tightened, more efficient and effective prosecution. So that's the conversations that they're having right now, her and her defense attorney. I think he had some really salient points there. And, it's very powerful to be able to get up in front of a jury and say, this woman's risking everything, being with her two children, to get up here and say, I am innocent. That's powerful, and that's not going away, and the prosecution can't change that. But it's a tough decision. It's a tough decision, and it really is going to depend on if there is a reasonable plea deal on the table, and if it's something that everyone's willing to live with.
Well, I'd love to see what our audience comments on this. Should the prosecution go forward, or should they try to cut a deal? We'd like to know, because we know our audience had watched this trial gavel to gavel. Guys, we've got to switch topics real quick. You may remember the old case of the Black Widow murderer. This is Barbara Cogan. She is to be released after, to the day, almost 30 years from the killing of her boyfriend, for the killing of her boyfriend, or estranged husband, I should say. Now, let me give you some facts here. 20 years after the murder of her estranged husband in 2010, she finally admitted to hiring a hitman to gun her down. She was sentenced to 12 to 36 years in prison. She stood to make $4.3 million in an insurance policy, which she collected $4 million, was a suspect for a long period of time. It took the police 20 years to uncover a link, get this, between her divorce lawyer and the hitman. So you have Barbara, who's getting divorced, her divorce lawyer, and a hitman. The cops made that connection 20 years later. In 2008, Martinez, the lawyer, was convicted of murder and received a 25-year to life sentence. In 2010, Barbara Cogan pled guilty to conspiracy to commit murder, and grand larceny. Here's the thing. She's getting paroled after 12 years, and it's caused an outrage amongst the community. I just want to give you a couple of facts with regard to that. She said at her parole hearing, essentially, that she wasn't really involved. She really doesn't remember. She was shocked about it. So she's denied responsibility despite a clear contradiction in the plea that she gave in 2010. She had cooperated with prosecutors and helped convict the divorce lawyer. The girlfriend of the estranged husband has said that this has just been an outrage to begin with, that she and her family have been harassed. She can't understand what parole is doing. And here are some quotes from parole you've got to know. They're saying to her, quote, "You've done a lot of work," referring to her treatment programs and volunteer counseling. And, quote, "It takes a lot to muster up strength and endurance to continue on after trauma. We will take that consideration into account as well." That's what they're saying to the defendant, that it took a lot to get over the trauma. Guys, I'll start with you, Lisa. On parole applications, we know that one of the biggest things that they look for is remorse and acceptance of responsibility. And she provided, based on all accounts, none of those things. The parole board has come into considerable attack for a long period of time, including recently releasing a cop killer. And a lot of people are saying, what in God's name is happening with the parole board in New York? Thoughts?
I wish I knew what was happening. None of this makes any sense at all because of those elements involved with that. And serving 12 years for having your husband murdered, being part of it, being on the lam for 20 plus years. She got to live free and enjoy her life while her husband's buried in a grave somewhere. It's atrocious. And the fact that she did repeatedly harass the lover of this victim throughout the years, even through jail, she was getting death threats. Her parents were being harassed nonstop. This is not somebody who's remorseful in any way for what she's done.
Adam, you could probably give us some insights being from New York, but I mean, I don't understand this as well. There are people that are serving significantly longer sentences for far less crimes. To Lisa's point, 20 years with $4 million. She was living the high life, harassing the family, accepted responsibility for the plea that goes before the parole board and essentially denies acceptance of responsibility, which at least in most states, certainly my state, is pretty much stamped denied. She's getting out on her first parole eligibility date when so many others are spending so much time and haven't been paroled for far greater offenses. Give me your thoughts.
My thoughts are just utter confusion. I want to correct what you said before about accepting responsibility and remorse being one of the bigger factors that they look at. No, it's the largest factor they look at. If you don't accept responsibility, you're essentially saying, not essentially, you are saying, I didn't do anything wrong and I have nothing to be sorry for. And the parole board looked at that and said, oh, okay, well, you didn't do anything wrong. You don't have anything to be sorry for. Let's let you out as soon as humanly possible. This makes no sense to me. I have never in my career had a client go before the parole board on their first time, not accept responsibility, and then get spoken to as though they were the victim and then shown the front door to freedom. It is absolutely insanity.
Yeah, and I'll just say for just the sake of saying it, and then are patting her on the back for her trauma that she suffered after she pled guilty to murdering. I agree with you, Lisa. This makes absolutely no sense. What are you doing, New York State Parole Board? If you're going to do it for her, start giddying up and getting to the rest of those people that are in for minor offenses. We're talking about criminal justice reform. Let's start right here. We got to take a break. We'll be right back.
Hello, I'm Fat Wayne Bryant, and I want to thank everyone for their support and their generosity, and I want you to know that I'm going to make the best of this opportunity.
Okay, this is a perfect segue after having talked about the Pharma case and the Black Widow murderer case that was released for murder after 12 years in New York. This black man, as you can see there, Fair Wayne Bryant, was granted parole after receiving a life sentence for stealing hedge clippers. I'm going to repeat that. A life sentence for stealing hedge clippers. And the state Supreme Court, as of August of this year, upheld that sentence. Only one dissent on the Supreme Court upheld a life sentence. Now, to be fair, he was convicted and sentenced under the habitual offender law, as some of you may have thought. And I thought that too. And I looked up, what are the things that he did that got him involved in that habitual offender law that sometimes can trap people the wrong way? And prosecutors need to use their judicious discretion when deciding to do that. That was meant for the worst of the worst people. Well, in 1979, he attempted armed robbery conviction. That's a serious offense. 1987, possession of stolen items. 1989, attempted forgery of a check for $150. And in 1992, simple burglary of an inhabited dwelling. Then in 1997, he attempted to steal the hedge clippers, was convicted, and got his life sentence. So, Adam, I'll start with you. I always used to say to the prosecutors under my command, you have to use the rule of reason, and you don't have to hit a fly with a sledgehammer. You know, many of these people are mentally ill and they're addicted and can benefit by services other than the one offense that had happened all the way back in 1979. His history was rather unremarkable in terms of severity or seriousness of a crime. And I just think it just sounds ludicrous on its face that somebody would get a life sentence, not 5 years, not 10 years, 20 years, a life sentence for attempting to steal hedge clippers. What are your thoughts?
Well, my thoughts are what a disparity this is compared to what we've talked about. We've talked about earlier in the hour the Sackler family who owned Purdue Pharma, that they were responsible for at least 500,000 deaths, and they got to walk away with $10 to $12 billion and totally untouched by crime. We just talked about the Black Widow who walked away with millions of dollars, lived free for 20 years, and then at the first opportunity the parole board had, even without remorse, they set her free. And now we're seeing in this case the result of the sort of predatory criminal laws that came into effect in the 80s and 90s that made criminalization of any crime so huge, especially in Black and brown communities. The fact that this guy was spending life in prison over this is disturbing. And you don't have to really be on one side of the political aisle or the other to think that. To say that stealing hedge clippers results in life in prison is outrageous. You know, I urge everyone out there to watch the documentary, The 13th Amendment, which gets into, on Netflix, which gets into the history of incarceration and really lays it out wonderfully to see how something like this could happen. You know, we're fortunate now that we're in a time where we're starting to roll these things back. But even the fact that this had to go beyond the state Supreme Court, that they upheld this sentence at first is astounding. It really shows that we have still such a long way to go to really truly get to a real equal justice for all place.
Yeah, and Lisa, why I love the story, and to Adam's point, we talked about the Purdue Pharma, where millions of people have been affected and died. We're dealing with the Black Widow murderer who got only 12 years on a murder case. And then we have this individual with a relatively minor record that gets a life sentence upheld by the Supreme Court with all but one justice. And this is why the ACLU is saying, and to Adam's point, and I felt this way as a prosecutor, it may sound counterintuitive, we have to stop these mandatory sentencing and increased sentencing habitual offender laws, because a lot of times our hands are tied, even as prosecutors, when we want to give somebody a break, because we realize that wasn't really what was meant for this particular person, although it fits within the technicality, and these people are being warehoused in state prison when others are being released for far worse things. And that prosecutors need to use that rule of reason, Lisa. They need to not pursue those kind of charges when you have somebody like this. There's got to be parity. Parity means consistency, grading, evaluation, so that people are not disparately treated. What do you think about all that?
One thing I know is that these types of laws in Illinois, where I was a police officer, we had the 3-time loser law, where people would go to jail for X amount of misdemeanors within a certain period of time, and it had to be enforced because these laws are on the books because of these crimes, no matter how petty they seem to be. What we've learned is they are not a deterrent. It is not helping with recidivism. It is not helping with them preventing future crimes. We're putting these people in jail. They could definitely have a beautiful life ahead of them and not go on that path any further if we pull these back, because I do believe that people can be rehabilitated for petty theft and for crimes like these. So we need to bring light to it. Pull away these mandatory sentencing. Let's take a look at them again, and also bring light to people who are incarcerated right now for things such as this, a theft of hedge clippers and getting a life sentence.
Yeah, you know, Adam, one of my experiences as the prosecutor was that we had opportunities to speak before legislative committees all the time. And when we said, and these are prosecutors, that guys, you are hand tying us, and you're hand tying the judges, and you're bringing people that fall within the technical aspects of these laws, where there's habitual offender aspects to it or mandatory sentencing to it, and it's just not the just and right thing to do. What we heard over and over again from both Democrat and Republican politicians was nobody wanted to be perceived soft on crime, and that's why it never changed, despite the fact they knew it was an outrage. Have you experienced that? And what do we do to break that?
Well, I think it's being broken is the good news. It was that way for a long time. The same with, you know, legalization of marijuana. It was tough to get a politician to say, hey, this makes sense for the community or the country. Back especially in the 90s, it was just these super predators are out there. We must punish, must increase sentences. But what that did and what that does is it takes the human element out of the reasoning that goes into charging someone and then sentencing someone. And that's true for the Rockefeller laws in the federal system, the drug laws that are so harsh. And it's true on these local state levels, too. When you take the power out of the prosecutor's hands, it leaves such little wiggle room to try to negotiate something that is actually fair. No prosecutor would say that this is a fair sentence. So to get back to your question, it is changing now. The tide of public opinion is changing. And part of it's, you know, crescendoing now with George Floyd, but it's getting there.
Absolutely. Yeah. Lisa, you're going to get the first comment the next time we're on the show together. Unfortunately, that wraps it up. I wish we had more time. You guys have a great rest of the week. You can find me at Bianchi ESQ on Twitter and Instagram. Stay tuned for our regularly scheduled program.